Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Turn to the third case on this morning's docket. That is case number 105182, State of Kansas v. James L. Simpson.
May it please this court, my name is John Kurth. I am the attorney for the appellee, James Simpson. This court granted review of his case from the Court of Appeals decision. If I may, Mr. Chief Justice, I'd like to reserve 5 minutes for argument on this matter.
In rebuttal.
Yes, sir.
5 minutes is granted.
Thank you. May it please the court. Ladies and gentlemen, this is a case that started in 2009 when the charges were filed against Mr. Simpson. Preliminary hearing was held in 2010, February 9th of 2010. We had a young victim in this matter who at the time was 13. After preliminary hearing, myself as trial counsel filed a motion for an independent psychological exam under the old cases of State v. Gregg and the subsequent cases. The court heard arguments on that on May 6th of 2010, asked us to reconvene on May the 20th of 2010. At that time, Judge Nafziger, the district judge in this matter, granted the motion for the psychiatric evaluation. We had an independent evaluator established and ready to perform the evaluation. The issue became the natural mother would not consent to the treatment or the evaluation. And Dr. Mintz, who was the evaluator, would not perform the evaluation without her consent because the child was a minor. We filed subsequent motions, and from May the 20th of 2010 until October 7th of 2010, the court had several hearings basically giving the mother and the state the opportunity to say, are you going to consent or not? And in fact, yes, sir.
Could I just stop you there?
Yes, sir.
The victim was 13.
At the time, yes, sir.
And the way I'm understanding, the victim never personally objected to the evaluation. It was just the mother refused to consent?
The mother refused to consent. Do
we have anything in the record to indicate what the victim's position was?
Mr. Justice, we do not.
Okay. All right.
It was simply the mother and the state inquiring of the mother. Judge Nafziger appointed a guardian ad litem for the minor child in this matter.
And that's my next question, is what was the guardian ad litem's position on this?
The guardian ad litem's position, as I recall, was basically she believed the court should not have granted the motion for the independent evaluation to begin with, although that motion had already been granted, and that it was the natural mother's position to take care of the business.
No, I understand that. So the guardian ad litem disagreed with the court's order for the psychological evaluation.
That was a portion of her report.
But did the guardian ad litem take an active role in her client not getting the evaluation?
No, she merely reported and basically indicated that she thought it was the mother's determination in the best interest of the child not to have the evaluation.
It was the mother's, not the guardian ad litem's determination.
Correct. I had actually...
So she was, what I'm curious of was the guardian ad litem an obstacle
Yes, sir.
in getting this evaluation or not?
No.
Okay.
No, she was not. I had, in fact, had requested the court to perhaps have the guardian ad litem be in a position to consent to that. Judge Nafziger was kind enough to her to not put her in that position. He basically said October 7th is basically the drop dead date. If she hasn't consented by that time, we've gone 5 months into this, then I will consider motions filed by defense counsel.
And was the evaluator correct that mother's consent was required for the evaluation to go forward?
That is the way we approached it. The court was not going to step in and order the evaluation of the child on his own. He wished to proceed with that directive that the evaluator wanted the mother's consent to treat the minor child.
Could you discuss at the Gregg hearing, or I'm calling it the Gregg hearing, you my understanding of the factors that you addressed to support your request for an evaluation were the veracity of the witness,
Correct.
which was primarily based on her testimony at the preliminary hearing, where, in your judgment, she had testified inconsistently with what she had told the officer or the detective.
That is correct.
And then I'm not sure what other factor you look to, because the transcript indicates that you basically agreed you weren't alleging mental instability, that you were talking about her cognitive skills, really
Correct.
a competency issue.
Correct.
You never suggested, the way I read it, that there ever was any mental instability, and the court didn't find that, the way I look at it.
I
They
think
cited age, which I'm not sure I understand.
age, there
and-
were some test scores from the school showing
That's
her
what he
low
cited.
cognitive ability. I know Judge Nafziger took that into account with the difference in her testimony from the statements to the investigating officer also. But it
He never
showed,
said, the judge never said anything about veracity in making his findings, did he?
he did not.
All right. So your prime reason was about veracity of the witness, and it seemed that he focused more on the competency issue.
I don't want to speak for Judge Nafziger, but that appeared to be correct. Yes, in granting the motion. And frankly, I could not find any help in the court to point us in the right direction as to what we do when that occurs. The cases that I have been able to find, but
Before you get into
sir.
that,
Yes, sir.
one more factual question. Was there any opportunity or were there any reasons given for Mom's refusal? I mean, did Mom specifically say it was going to be an emotional trauma, or was there any? Does the record indicate any specific reasons for her refusal to consent?
Mr. Justice, the record is pretty sparse. Mother was never present to give her statement to the court, and the judge did not order her to comply or to appear. It was basically, and this is Mr. Serra's predecessor that we were dealing with at the time, basically reported to the court what she wished to do, as did the guardian ad litem, and it was basically she wasn't going to consent. Just a no reasons given.
Okay, thank you.
We believe that the court was correct in his ruling. We filed a motion to limit or exclude the victim's testimony based upon her failure to comply with the court's order. Judge Nafziger, we believe in his discretion, granted that motion, saying, here's the deadline, October 7th, 2010. We came back then. We filed a motion, and Judge Nafziger ruled that based upon no evaluation and based upon the due process rights of the defendant and his ability to present a defense, that that witness and her statement should not be allowed in court. The state took an interlocutory appeal from there. Court of Appeals ruled basically on the record that was before them that I believe what they said was Judge Nafziger ruled her incompetent to testify. We don't believe that is correct or what we were asking. We were basically asking, both of us, I believed, what do we do when a child victim isn't able to be evaluated, when an order is granted to have her evaluated independently? We believe that Judge Nafziger made the correct ruling. I don't know what more he could have done.
Let me circle back for a second just to make sure
Yes, sir.
I correctly heard you. Do I understand that Judge Nafziger made no determination or inquiry into the mother's motives behind denying consent?
That's my recollection, yes, sir.
One of the concerns I have is that and I'm not saying it happened here,
Sure.
but some of the cases that we've had up here, the mother has wanted to help the defendant in presenting a defense or denying evidence. And it seems like that ought to be a line of inquiry. before the district court issues its decision. And so if that wasn't done in this case, that's why I'm particularly interested in it,
Sure.
because I may want to focus on that a little bit. So, so there's no evaluation, just he's told, no consent, and so therefore he makes his ruling.
Correct.
Okay.
Correct. Mr. Justice Biles, I can state, being trial counsel on this matter, that your fear of perhaps the mother wishing to assist the defendant, that was not present. They were fully willing to go forward.
Yeah, I wasn't trying to imply that.
I know that.
We do
but
get
just-
cases like that.
Just so you know,
Okay.
that wasn't an issue here. It didn't appear to be, certainly.
Counsel, besides the...
Yes, sir.
The option of dismissing the case, were other options considered or provided to Judge Nafziger?
The option that the county attorney at the time provided was to basically set a hearing to determine the witness competency. Basically, the two-prong test: is the witness competent to testify before you grant a motion in limine, or would the evidence be otherwise inadmissible? And then, should he rule prior to trial?
That would just
Go
be...
from there, but
Yeah.
that was the only other option that was provided to them.
And that would have
I had-
been independent, that would have been independent of the evaluation that was ordered and then consent was refused.
Correct. Our position on that was simply, if you can do that and have a hearing, she's already testified the victim's already testified at preliminary hearing. If you find her competent, we haven't made any progress. We're back at square one. You still ordered the evaluation, and there's still no consent, so we're back where we started. Our position was we didn't believe Judge Nafziger had any other option at that point in time.
What would have been wrong with giving a jury instruction that said, I ordered the child to be evaluated and there was a refusal, and so there was no evaluation? And just let the jury know that that's the incapacity that has occurred with this particular witness, much like other instructions when there's a problem.
Certainly, that would have been one option. Our position on that was it was the due process argument. It basically, not allowing us to have the evaluation defeated us from having the ability to present a defense on this matter, if there was one available, as to the evaluation. And to let her go ahead and testify at trial and then be instructed later, although that was not an option, I think would have defeated that purpose.
But she was still going to, if she testified at trial, you could cross-examine, you could present all of her inconsistent statements. It really didn't
Sure.
prevent your defense.
It wouldn't prevent
changed it.
defense. It would have changed it, and it certainly would have left us without one part of a defense if the evaluation had been performed.
Possibly, yeah.
Possibly, yeah, you're-
Possibly.
You're kind of jumping ahead, assuming the evaluation would have been favorable.
The evaluation is a two-edged sword, that's
Exactly.
correct. Yes, sir.
Justice Johnson, you had a question earlier?
How do you label the judge's actions? There was, the Court of Appeals went through several categories of, was it a sanction, was it, what is your position as to how best to label what the district judge did?
I filed a motion in limine, in all honesty, with this court. I had dealt with it as a sanction. I don't know if that is a term of art, that was the appropriate term, but that's the way I had dealt with it. Basically, you're not complying with an order of the court, therefore you have a sanction as a
And
result of that.
who did you believe was being sanctioned?
It certainly wasn't myself or my client. It would have been the state that would have been sanctioned, even though they weren't necessarily a party to that. They are. That's their witness, but for lack of a better word, that's the way I would term it.
And there wasn't a dismissal. It was just that the motion in limine was ruled on in your favor, and then the state took an interlocutory appeal.
Correct. The case was not dismissed. And I didn't think I could talk for 10 minutes, but I'm done, unless there's any more questions.
Your motion in limine essentially did, though, treat this as an evidentiary issue. You asked the trial court, well, you mentioned a couple of statutes, 6460 DD, and you mentioned 6408, giving the court discretion to allow evidence and to allow a witness to testify. You don't necessarily talk about competency, but then that seems to be how, again, when you go to the transcript, it seems that Judge Knopfsinger was looking at this as a competency issue again. Because he talks again about the competency of the witness. And he says he's not going to have an evidentiary hearing, which is what the state had requested on the competency issue, because he seems to think that he needs this, that the defense needs to get this evaluation before there can be a competency hearing. So he's kind of mixed up these two concepts of the Gregg hearing and the competency hearing.
I believe the transcript is correct. You're correct that he said, well, we're not going to have the hearing because unless she has the evaluation, I'm kind of paraphrasing.
Yeah.
We're not going to have a hearing on the competency because she's not had the evaluation, so she's not going to testify.
Right.
Even though she'd already testified at a preliminary hearing. There wasn't really, I don't want to say I presented an issue as to competency because she had testified at preliminary hearing.
Well, you did ask to have it disqualified, and you did.
I did.
In your motion in limine, it sounds something like a competency sort of hearing.
And in all honesty, I didn't know which other way to point. I didn't know any other options that were available other than ask her to be excluded as a witness if they weren't going to comply with the court-ordered evaluation.
Well, you indicated, and I want to question you about this, in response to one of my answers earlier, you said something about your position was when the state said, we need a competency hearing, and the judge said no, you said your position was, well, we didn't want a competency hearing because basically she'd already testified at the preliminary hearing.
Correct.
And presumably, she answered the questions about understanding how difference between, truth and fiction, essentially, and so your position was that we've already done that, this isn't a competency issue, it's something else, but I don't see that in the record where you took that position and distinguished between competency and what I see as more of a credibility issue.
The record is you're probably correct with that I didn't take that stand. I guess my position, she'd already testified at preliminary hearing, we'd hit that hurdle. We didn't need to revisit that. And again,
well, didn't you have a hearing on whether to order a Gregg evaluation?
We did.
And wasn't that essentially the hearing on whether there is a question about competency and we need to get professional opinions in that regard?
It would be.
And so when the other hearing was requested, you were still back where you were before.
And that was our issue we can do that, but we're right back where we started. So,
any further questions of counsel? Thank you, counsel.
Thank you.
Your Honors, may it please the Court, my name is Michael Serra. I'm the Deputy Jefferson County Attorney representing the State Appellant in this matter. I've done my best to kind of examine the record to determine what happened. I will first say the record is pretty interesting, to say the least. There was a hearing held on the Gregg evaluation, and the Court is quite correct in that the District Court focused on the low test scores and the ability of the testifying witness to determine what was true and what was not. The defense mainly challenged the veracity of her statements, although it looked to me that they were implying that because of the low functioning IQ scores that she may or may not have been able to tell. However, that was pretty well addressed at the preliminary hearing.
Is that on the table? Is the court's ruling that Gregg evaluation was warranted in this case, is that issue on the table in this hearing? Because I don't see it.
It isn't, Your Honor.
And is it germane to anything that we have to decide today? Do we go back and say, maybe it shouldn't have been ordered, so the sanction was too severe? Or do we take it as an order of the court that's been unappealed that a Gregg evaluation was required?
Your Honor, the To answer your question, I don't believe that question is before the court regarding whether the evaluation should have been ordered or not. Specifically, in the state's reply brief originally submitted to the Court of Appeals, the county attorney at the time specifically stated that whether the Gregg evaluation was justified was not being appealed. The only issue on appeal that the state seemed to take issue with was the appropriate sanction for the mother's refusal to consent to have the victim undergo, or excuse me, the alleged victim undergo the evaluation.
And so what is the appropriate sanction in your mind? You have here an evaluation that's been ordered. The court says this is what you're going to do, doesn't comply. If the court doesn't take any action, what's to prevent anyone from ignoring a court order?
I completely agree, Justice Rosen, because the sanction was appropriate. And I view this after reviewing the record, specifically the district court's ruling.
You agree the sanction was appropriate?
I don't agree the sanction was appropriate.
Some sort of sanction.
I do agree some sanction.
I misheard you, okay. I was going to say then, what are we here for? Okay.
The reason I view this as a sanction is the district court very specifically said, I am excluding the testimony and all evidence from the victim because of the failure to comply with the court's order. That was ordered at the final, that is in the final transcript on the proceedings in this case before it was sent to the appellate courts.
So what sanction do you think was appropriate?
Justice Breyer, I'd like to explain my position, but I would have to go off brief to do it. I had to do some significant research on this case after I had inherited it with all the briefs on it, and I have found there are some other jurisdictions that have dealt with this issue, if the court would be so inclined to let me do that. However, I don't want it, again, these were not briefed, and I'm only using this to kind of frame my position on what the appropriate sanction would have been.
Back up here just a little bit. What is your responsibility in controlling the case that you filed and charged in this? This is a very serious matter. It has consequences of a life sentence. And don't you have a responsibility with your capacity as representing the state and the people, but also the victims in this case, to say, Mother, get your act together here. This case is going to go forward, and unless you cooperate, I'm not going any farther with this. Because she's really the complaining witness here.
Absolutely, Your Honor. And in this situation, the defendant is entitled to full discovery on the case. In this situation, the court found a compelling reason to order the Gregg evaluation.
Right, which is unusual.
Is unusual.
Very unusual, and
as a matter of fact, I was only able to find 4 or 5 Supreme Court cases where that actually has been ordered.
It just doesn't happen very often.
Now, we've also, as a matter of first impression, never dealt with the fact when a parent takes control and says, I will not subject my child to this exam. That has, to my knowledge, never been decided in this state. The issue of the state's responsibility, and it was said several times to the trial court, was that we have no control over Mother because she's not a party to the case. I don't agree with that statement because the victim is not a party to the case. Neither is anybody else except for the defendant and the state as a collective. Now, I think that the state, other than requesting the girl be put into state's custody as part of a SINK case in order to take control if the mother was doing something against her best interest, we had very little control over Mom's actions.
What about the court, though?
Could
the court have ordered Mom in to have a little chat?
I believe they certainly could have done that, Justice Breyer, and the fact that the Gregg examination is an inherent power of the court. It is created by the court, and it is not statutory. I think the court certainly could have invited Mother in to explain her reasoning. Now, I will say in the guardian ad litem's brief and some of her argument to the court, she did advise the court the mother's position was this had been such a trauma for her daughter, she did not feel that a psychological evaluation would be in her best interests. The guardian ad litem also brought up interests of due process as to the mother regarding her right to parent and right to determine the medical needs of her child. The court, in this situation, the district court, did not do a balancing test to determine which competing due process rights were paramount in this situation, the defendant's due process right to a fair trial versus the mother's right to parent her child.
Could the mom have been brought in on indirect contempt?
I'm not entirely sure. That is the million-dollar question. I believe that the way Kansas law reads, I believe she could have been cited in contempt, yes, for failure to obey a court order. She certainly interfered with one. Not for nothing, 2, she is also an endorsed witness on this case. Mm-hmm. So she is technically subject to the court's subpoena power. I believe that she is, I don't believe it would have been outside of the court's authority to order her to come into the court and explain why and cite her for indirect contempt should she have continued to refuse.
Given that the source of the...
I'm sorry, go ahead.
Given that the source of the Gregg evaluation is the inherent power of the court, doesn't the court also have an inherent power to say, I'm going to strike the testimony?
Absolutely. However, under the State v. Clovis decision, striking the testimony in the degree the court did is, in the state's opinion, an extreme sanction. I believe that lesser sanctions might have cured the violation, so for example, an indirect contempt citation. The other cases that I've read about, Justice Breyer, deal significantly with, does it prevent the defendant, if a Gregg evaluation is ordered and failed to be complied with, does it completely bar the defendant from presenting a defense? Are there less intrusive alternatives to allow the defendant to do so?
Let's talk about that for just a second. What is the purpose of the Gregg evaluation?
The Gregg evaluation, Justice Breyer, to my understanding, is to determine whether there are significant mental instabilities of the alleging child victim, and it's only in this state been extended to child victims.
And is it intended to determine the competency of the witness, or to just give the defendant ammunition and cross-examination?
I don't believe that it's designed to establish competency, Justice Breyer, because there have been other cases where competence has become a separate issue.
Yeah, there's a separate proceeding for that.
Absolutely, and I think that is one of the things that there was some confusion, and I noticed there's confusion in the briefs about what this issue was. I don't see the district court ruling that the girl was incompetent to testify. I see that the failure to comply with the court's order for the Gregg evaluation was what the district court ruled on, and hence excluded the testimony as a sanction for failure to comply with that order.
But wasn't the Gregg case about veracity, and didn't we specifically say in that case that the concern is about her mental and emotional condition as it pertains and affected her veracity?
Yes.
And so, regardless of what, everybody talks about later, the whole point of the Gregg evaluation is to talk about veracity, and yet the problem we have is we don't even have a finding that there was a question about her veracity. And we don't have any, and even the defendant recognized that he didn't care, he wasn't alleging she had any mental instability. It becomes this issue about her competency is my problem, and nobody ever talks about veracity again.
Justice Moritz, if I recall correctly, the defendant did bring up in the transcript of the first motions hearing on this case, there were some concerns about inconsistencies.
Right.
I do agree that, and this court has ruled, I think in Berriozabal, that inconsistencies do not per se lead to questions of veracity of statements. I do agree that... I don't think the judge talked about veracity. He heard all that, and he wasn't focused on that. Nobody ever talks about veracity, and that's my point. That's the point of the Gregg evaluation. And then we get totally distracted and we start talking about competency, and I can see why the state focused on competency, because that seems to be what the judge is focusing on. I agree, and I think that, and again, I'm not going to speak for Judge Nafziger, but it's one of those situations where do you assume that a low-functioning person or a person who is mentally handicapped automatically, as a result of that mental deficiency, have issues with veracity?
Well, the defendant wasn't even arguing that.
And I'm not saying that was the issue, Your Honor. I think that in this situation, the court, you are absolutely right, focused on the competence of the witness to testify based on the fact that she had a low IQ.
And I guess I'm surprised that you would say so quickly that this judge had the power, inherent power, to completely strike her testimony as a sanction, when the point of the Gregg evaluation is to go towards credibility and veracity. That's the whole point.
I think
why would you say that a sanction, an appropriate sanction, would be to strike her testimony as opposed to something that would just point out the potential lack of credibility?
And if I misspoke, Your Honor, I apologize. I didn't say I thought it was an appropriate sanction. I said that I thought the court had that power. I do believe that it was an extreme situation here, and that I do believe the court was in error in imposing that kind of sanction. I think there were lesser sanctions that would have served the same purpose.
And we've talked about your disagreement with what you think you characterize as the extreme sanction, and in response to Justice Breyer's question, I think you told us, well, indirect contempt of court could have been another sanction. Any others that come to mind based on your review of the case law? We understand that they're not in the briefs, but just to help the court out.
Your Honor, Supreme Court of Nevada has had a similar situation come up, and they are at a different extreme than we are. They do not find that the victim, especially a child victim, has a right to refuse their version of a Gregg evaluation. The appropriate sanction there in the past has been if a state expert is going to be testifying about as to the statements made by the alleged victim, the state is barred from presenting that expert, and that expert includes interviewing Safe Talk persons and police officers. The state of Florida, on the other hand, goes to the other extreme, says we're not entirely sure the court has the power to order this and have it enforced, but other sanctions are appropriate as to, as Justice Biles pointed out, informing the jury about the fact that this examination was ordered, it was not complied with. I would say that I'm not sure if the court would have to advise them about what the purpose of the evaluation was, although I think that might be helpful for a jury to consider.
And do you also have to inform them of why it didn't happen?
I think in this situation, Your Honor, that would be appropriate.
I mean, the difficulty I have with the whole idea of advising the jury, I think, is that it has the potential of increasing the sympathy for the victim. I mean, this mother's position is, I don't want to re-victimize my daughter and put her through this trauma again. And it just seems like if you tell the jury the whole story, you've added to that, and I'm not sure that that accomplishes the purpose of trying to make the procedure fair for the defendant, who's perhaps had a limitation on what our law might allow him to do, or the judge has ordered to have to happen.
And I don't disagree. And again, this is one of these situations because it has never really been dealt with as a trial case, in particular in this state, but many others. The appropriate sanction for this kind of situation has never been dealt with. This is truly a matter of what are the best of bad options.
And so do we leave it totally as a discretionary call of the judge, and are we then applying an abuse of discretion standard here?
I believe at this point, Your Honor, the way that our case law is currently structured in the absence of statute, it is an abuse of discretion standard. And if reasonable minds could disagree, then discretion is not abused. If reasonable minds cannot agree, or can't agree that this was inappropriate, then it would be an abuse of discretion. Because
I wanted to clarify about when we're talking about other state, what they've done and the fact that you're bringing it up for the first time today. Traditionally, or recently, we have held that, especially defendants, if they want to bring up other case law, that they have to comply with our Rule 6.09. I seem to have perceived that you understand that. And so what is our ability to consider case law that wasn't cited and wasn't put in the 609 letter?
Your Honor, I don't know. I think the court has discretion to take into account whatever you'd like to take into account. Again, I bring this only to the court's attention to kind of frame my position.
No, I understand, and you presented it like you should, but you seem to realize that it hadn't been laid out there like our rules say it's supposed to be.
I agree, Your Honor, and I think that is completely the fault of the state, and that we've had multiple attorneys on this case who have kind of been just churning through, and I happen to be the person whose lap it landed into when it got to this court. So that is kind of at least where I'm at this point, Your Honor. I do feel that there are lesser sanctions that could have been imposed at the district court level that would have served to protect the defendant's rights, but also not have.
Can you outline what those would be? If you were the trial judge here, what steps would you have taken?
Your Honor, I am out of time. If the court would like me to continue. If I had been the trial judge in this case, Your Honor, I would certainly have had the mother come in for hearing to, number one, determine exactly, instead of having to go through not only the state's attorney but the guardian ad litem, who is not representing the mother's interest. I think there was some confusion at that level about as to what reasoning she has for refusing the examination. And if she continued to refuse, I do believe I would have held her indirectly in contempt. I think that would have been it wouldn't have been fun for anybody, Judge, and as a trial judge, I don't think you ever want to impute those kind of penalties on someone who is having to go through this because their child has allegedly been victimized. But at the same time, not only the defendant's rights have to be protected, but the interest of the state in prosecuting potential offenders has to be respected too. And if there is this bar in from a competing witness, that cannot be accomplished.
And let's assume the mother still says no. Do you put her in jail, or do you strike the testimony?
I think at that point, Your Honor, especially It would depend greatly, I think. I would hate to think that a trial judge would have to put a mother of a child in custody for failure to comply with a court order. At the same time, I hesitate to think that a mother would want to obstruct a prosecution, especially alleging what this one alleged.
That gives more teeth to it. If the mother is aware that her continued refusal could result in dismissal, that certainly gives more teeth to the propriety of the sanction, doesn't it?
I would agree. Any other questions?
Any more questions of counsel? Any further presentation?
No, Your Honor.
Thank you, counsel.
Ladies and gentlemen, honestly, I don't have any further argument other than what's presented. If you wish to subject me to some more questions, I'll be happy to answer those. Otherwise, I'll sit down. Whatever the court pleases.
Just so I'm clear, is there anything in the record that would indicate that the mother had any problem with the trial going forward? Before this issue of the evaluation came up,
Yes, sir.
was there any indication that mother had any problem with the trial going forward and her daughter being called to testify
No.
in the trial?
No, sir.
It's strictly the evaluation itself.
It appeared to be so, yes, sir.
Very good. Any further questions?
Well, and just to clarify, I think you mentioned several times, but the child had already been put through the trauma of preliminary hearing.
Yes.
Okay, and mother understood the child would be subpoenaed and have to testify again at trial and be put through that trauma.
Correct.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. Court is in recess until 9 o'clock tomorrow morning.